Hello, hello, hello. Welcome, welcome, welcome to Legaleaze, please. I am your host and your guide, your conversation partner. I am Natasha Robinson. I am the creator and curator of Legaleaze, please. We are a digital platform that is designed to build you up by breaking it down, it being all types of barriers that lead to comprehension, that lead to activism, that lead to liberation and freedom. And so we are here to decode, demystify, and deconstruct legal language. And so if you are watching at this time, I want to greet our viewers on Facebook. I want to greet our viewers on LinkedIn. And I wish to greet our viewers on YouTube. That's right. We have three audiences that are going to be watching live or later. And I want to be able to greet you all and ask that you would click like and share. Also, if you are watching live or later, that you would do so and that you would share it and also put some comments in so that I'm able to know that you are present and in the house, whether you are here with me live or if you are here with me later. So I just want to go ahead and get started. This is going to be a conversation, if you will, part lecture, if that's what you want to call it, as well as part conversation, part information, just, all the things. And so if there is any question that you have, any comment that you have, we are pretty informal around here, which while this is on uh, different spaces and places, different social media platforms. This is also the place where we are just, family. And I will be able to see you and shout you out. Good morning, Devon. Good morning, Commander Foster, all the way from Bahrain. That's right. We are international. We are global because our supporters and participants are global. So thank you for being here. Let me go ahead and put down where you are so you know where you are. Welcome to Legaleaze, please. Okay. This is where you are. And again, my name is Natasha Robinson. So we are going to go ahead and get started. I also want to say if anybody is texting me right now, please stop. Now, you know who you are. So I want to say your names on the World Wide Web, but you know who you are. And so it's something about every time I go live, my family members, blood and extended, they want to start talking. And the buzzing is what gets things jumping off. So I want to make sure that anybody who is about to send me a text, as funny as it is, do not send it. Just wait until just wait until I finish so that I can respond accordingly. All right. I am trying to get the information that I need on here. I'm trying to get it on the screen to you so that you are able to see it. And so here we go. All right. So let's go all the way to page 1 so that you're able to, because my goal is to have you all informed and done within the hour. And I also want to say that I saw somewhere online that the Supreme Court is handing out different legal decisions. They just ruled earlier as it relates to Native American children, Indian children, and whether they can remain with their tribes if they are adopted. I believe that's what the topic is. And so what that means overall is that the Supreme Court is passing out these decisions before their term ends on June 30th. So affirmative action and the future of it could be raised as early as today, but it will be raised no later than June 30th. Also understand that it was on in 2022, this time last year, that the Supreme Court issued a decision via Dobbs versus Jackson, which was the Supreme Court case that overruled and overturned the precedent of Roe versus Wade, which is the landmark case that gave those who identified as women abortion rights. And so that is no more. That is left solely up to the states. So now here we are a year later looking at affirmative action. All right, so this is what we are going to be doing today. If you have not already, click like and share so that this information can be disseminated. All right, so let me go back for a moment so I can get this off the screen. It has been a minute since I have been on the pop-up, since I have been on Legaleaze, please. So just give me a minute so I can remember how to ride a bike, how to ride a virtual bike. Okay, I think we are on. So let's go ahead and get started. Today's pop-up Legaleaze, please presents will affirmative action be affirmed? That is the question that we will be trying to engage. All right, now our purpose and our mission of Legaleaze, please, if this is the first time you are here, understand that we are here to decode, demystify, and deconstruct legal language for the everyday activists. The everyday activist I define as someone who may not have an official platform or an official following, if you will, but in fact, they are persons that care about what is happening, and they may inform by social media, they may inform by way of conversation or text or whatever. And so the everyday activists can be empowered with everyday information. And so what we're doing is we are strengthening our focus by making sure that you do not have to have a huge constituency of people with whom you're connected, but you can still be an everyday activist. You can still read about the news, read the news, you can discuss it, you can research, you can do all the things to retain and enhance your power to make a difference right where you are. We also build you up by breaking it down, as I said earlier, breaking down all of the barriers of oppression, barriers to comprehension, barriers to understanding and access and knowledge. The Adinkra symbol that is posted is the brand, is the logo of Legaleaze, please, and what it stands for is lifelong learning. It stands for lifelong learning. And so in this space and place, we are both teachers and students. We are all educators, and we are all interested in the future of each other being liberated and being free. Lastly, Legaleaze, please, is about providing a trifecta for triumph, which is a robust learning experience for your mind, your body, and your spirit. So we do not redact parts of ourselves in this space. We bring our whole selves. We bring our identities. We bring our truths. We bring our experiences. And it is in the midst of that we learn about what the law is, what the law says, and what the law does, and our participation in that role. So today's community conversation, this is just an overview. Like I said, I got a long way to go and a short time to get there. I am just going to talk about what affirmative action is legally, when it's legally permissible. I will give a brief overview of affirmative action in the courts. I will talk about why we got here or how we got here. What are the cases that brought affirmative action to the Supreme Court? Just a brief overview of the arguments that were made, the predictions, and then the impact, meaning how is the impact of what the Supreme Court decides, how is that going to impact us individually and collectively? So what we're going to do now is go back. We're going to go back for a minute. So affirmative action has been defined in many places by many people, but the definition that I'm using for today is from the Oxford Handbook of Practical Ethics, which states that affirmative action is, quote, intended to end and correct the effects of a specific form of discrimination, end quote. And so affirmative action first came to pass through an executive order. And then the very first time that I can think of that it was addressed legally was in the late 1970s, where you had different people Well, started in the 70s. You had, since 1971, rather, approximately 41 federal cases where different parties, those are the persons that have brought the case or asked for the case to be heard in front of the Supreme Court, they have addressed affirmative action or some iteration of it. Now, affirmative action is many things to many people, but where it has probably the biggest impact is in the fields of education and in employment. Affirmative action was created to right the wrongs of systemic and systematic discrimination that is present in academic decisions, in hiring decisions, and it has been expanded to include coverage by the military, by human resources departments, and it is designed to prohibit, reduce, eliminate race-based bias, among other things. And for the purposes of this conversation, I'm only going to talk about race because that is the basis of the lawsuits that are in front of the Supreme Court right now, which the Supreme Court is going to issue a ruling any moment, any day now. Okay, so that's what I'm focusing on only, is on race. Now, in order to get a case to the Supreme Court, it does not happen in this way, where if you are ruled against, you write a letter to the Supreme Court and says, please hear my case, and then the Supreme Court does. It does not work like that. There are hundreds upon hundreds of cases that are ripe to be heard by the Supreme Court. To put this in context, the Supreme Court is the highest court in the land, the highest court in the United States. And they are the group of people, 9 justices to be specific, that rule on different issues. And those issues then become law or they become precedent. So in order to rule out, in order to filter out all of the cases that comes to the Supreme Court, or here's the correct term, that are appealed to the Supreme Court has a device that is called a writ of certiorari. And what that does is once the Supreme Court looks at all the issues that are coming to it, the justices, decide which cases they are going to hear. They do not have to hear every case that is appealed to them. They get to decide. Now, what is interesting is that in the last 4 or 5 years, there have been vacancies on the Supreme Court. And one of the campaign issues is if the United States president will have a Supreme Court pick or Supreme Court justice that will be present during their presidential term. And so if you think about going back to when Barack Obama was president, that he had a Supreme Court pick, but at that time, Congress was stacked against him in terms of political parties. So the person that he nominated, the Supreme Court, the person that he nominated to the Supreme Court, who was Merrick Garland at the time, the Congress, particularly the Senate, led by Mitch McConnell, refused to show up. They refused to even hear about the nomination. So what ended up happening is that Barack Obama then completed his presidential term without that second Supreme Court justice pick, which we now know Merrick Garland is the prosecutor of the United States. There's a word for it, Attorney General. That is who he is now. But at the time, he was going to be nominated to the Supreme Court, and the Senate, which is the body of Congress that approves nominations and has confirmation hearings, they refused to hear it. All right. So after you had Barack Obama being the president, then you had the other one, the one who is now facing indictments and lawsuits and things of that nature. What happened was that he had 3 picks to select and nominate to the United States Supreme Court, and it was Congress who would approve or deny those confirmations. Well, there were 3 persons that came out of that time, and that is what filled the vacancies, if you will, of the Supreme Court. because Supreme Court justices are there for a lifetime. They can either be removed, which I've never seen that happen. They can resign, which I have seen that happen, or they can die while they are still a sitting Supreme Court justice, which I've seen that happen. The reason why that is important is because you had on the Supreme Court now 3 justices who are labeled as being very conservative in their rulings, in their beliefs, in their decisions. And so when you add that to the already conservative judges that were sitting there, out of 9 judges, you have 6 who are considered to be very conservative. And so anything that is progressive, that is liberating, they are not going to vote for it. And not only are they not going to vote for it, they are going to couch their language in law that strictly confines and interprets the United States Constitution. So on the Supreme Court now, out of 9 justices, you have 3 who are considered to be relatively progressive, and then you have the remaining 6. How this works with the writ of certiorari is that persons who want to bring lawsuits to the Supreme Court is all about timing. And I believe these 2 cases, as well as other cases that have come to the Supreme Court, there are people who are pushing them and saying, now is the time to try and overturn a thing. This is how abortion rights was overturned, and this is why affirmative action now sits on the docket, because you have the right number of people who are able to not just overturn something, but to legally do it, to legally create policy and to do away with those things, which a good number of people saying it no longer fits the nation. Okay, the problem is the people who make these determinations are not the people who are affected by or who are supported by it the most. All right, so the granting of the writ of certiorari, that is the document that allows cases to be heard to the Supreme Court to determine the constitutionality of affirmative action. That being granted is no accident, because now you have the justices that are needed to overturn different legislation, different cases, different laws that would legally protect, legally support, legally benefit those who live in or rather reside or are disenfranchised because of their race or because of their gender or because of their physical ability, disability, you name it. And so this is really just, in my opinion, the beginning of cases being overturned. So when you are reviewing certain cases or certain issues by the Supreme Court, there are legal standards or legal thresholds that the Supreme Court abides by, and they are called a standard of review. So whatever the issue is, it's not just whether or not the law should be turned or there should be a case that overturns years of precedent. There is a standard of review. And whenever the Supreme Court is reviewing the legitimacy of a protected right, there are 3 standards. At the base, at the lowest, you have a rational basis, which is the lowest level. And the question that the Supreme Court asks is, does the governmental regulation serve some legitimate governmental interest? Okay, that is the lowest level. That's a very low threshold to get over. The next level is a little bit higher, which is called intermediate scrutiny, which is the medium level. And then you have, for the purposes of this discussion, what affirmative action, what it's going to be reviewed under. It's going to be reviewed as what's called strict scrutiny. That is the highest level of review by the Supreme Court. And it's the highest level because anything that is a protected right, if it is regulated or if there's a party that is trying to put a limit on something, that triggers this type of review, or that merits or necessitates, rather, I don't want to say triggers, that necessitates the highest level where the Supreme Court justices are looking to see if a state interest is compelling, Is a rule or a law, is it compelling enough to achieve a particular state interest? And so the standard of review for affirmative action is the Supreme Court determining, is the use of race necessary to achieve a compelling state interest? In this interest, or rather in this case for affirmative action, the Supreme Court has already ruled in earlier cases that diversity in higher education is a compelling state interest. And as a result, affirmative action is okay. Okay, so in prior cases, not only did the Supreme Court necessitate or believe that the use of race to consider whether a person is entering into higher education, whether a person is entering into employment, that diversity is a compelling state interest. That was before. Now, you also have what are called legal precedents. Legal precedents are nothing more than cases that set a pattern, cases that set a pattern from here on out. And a case that I can think about that was a precedent was Plessy versus Ferguson, which in 1896 was a Supreme Court case that set the precedent or the legal pattern for separate but equal. It was Plessy versus Ferguson. That was a constitutional case that stated that segregation amongst races was okay as long as it was equal. So what ended up happening is that, particularly in places south of the Mason-Dixon line, you would have, as my mother would talk about, because she was from Mississippi and she is alive to tell these stories, they would have two fountains, and one fountain would say for coloreds only, and another fountain would say for whites only. The colored fountain was broken down, the water was dirty, it was not fresh. Of course, the fountain for the whites was full of clean water, it was working, it was healthy for its users. If at any point those who were Black would use the white fountain, they could be arrested. And that's if they faced the law. A lot of times they faced lynch mobs or communities that would be their own lawmakers and law caretakers, if you get my drift. And so Plessy versus Ferguson was the precedent that set the legal pattern on how states are to enact laws that separated the races in this case. And then there is a precedent of Brown versus Board of Education. There are two of them. 1954 said that segregation was no longer constitutional. Rather, it said, the Supreme Court at that time, that segregation was unconstitutional. And as a result, desegregation had to occur on the federal and the state level. So that was a precedent. Brown versus Board of Education 2 was in 1955, where the states came back and said, hey, you said we had to desegregate everything. Well, what is that going to look like? What is that going to feel like? What is that going to sound like? And the Supreme Court said, well, desegregate, quote, with all deliberate speed, end quote. That was a precedent because now you had the Supreme Court saying, how you do it is none of our business. Just make sure that you do it. And so that is why you had the Civil Rights Act being carried out, which was to enforce and to put into place those rights that were established but never trickled down from theory into practice. Okay, so precedents are legal patterns put in place. As it relates to affirmative action, you have three cases that were legal precedents. You have Regents of the University of California versus Bakke, which stated that there could be no more racial quotas. You could not automatically give so many points to African American students, even though the awarding of the points was recognition of the fact that African Americans had been treated unfairly, discriminatory in higher education, even though we were brilliant, smart as a whip, and demonstrated that academically our places were not given to us, and we were discluded in a lot of places. And so you had colleges and universities trying to figure out how could they right that wrong of racial bias in higher education. And so what ended up happening was one of the schools, University of California, gave so many points for the admissions packet, the admissions process. And so you had a student that said that I can't get in because you letting all of these in. Okay. And so the University of California Bakke case is what it's known, says, look, you can't stack points for those of different races. You have to figure out a way in which you can establish diversity in your higher education, but not do it that way. Okay. Then you had the case of Gratz versus Boilinger, which there was a case. The Supreme Court says, okay, now look, we said no quotas in Bakke. Now we're saying in Gratz that even giving points. So whereas in Bakke, you had a certain percentage of seats where you said we can't touch these seats because these are for historically disadvantaged and disenfranchised students. That was a quota. We're going to bring so many of these particular groups of students in our higher education. Bakke said you can't do that. Then Gratz said, okay, well, instead of making quotas, you also cannot use a point system. You can't just say, well, because Natasha Robinson identifies as an African American, that she automatically gets 20 points, despite the fact that the systems that she's been trying to get in have been blocking her for no other reason than her race. They said you couldn't do that. Also decided in 2003 on the same day was a case called Grutter, which says that race could be a factor in administration's consideration as long as it was not the only factor. So that you could consider race, but race could not be the only reason why you admit a student into higher education. Because if you did, then that would result in you being unconstitutional, because you had students that were saying, look, I can't get into these classes, these institutions, because now I'm engaging in what is called reverse racism, which I think is a crock, because I don't think there's such a thing as reverse racism. But whatever, you didn't ask me. And so that case was heard on the same day. Gratz and Grutter were heard on the same day. And those set the legal precedents for higher education, and then employers, and then other organizations and institutions trying to decide how can we establish diversity and not let it only be on or about race. Okay, so now we have the current challenge. The current legal challenge is where you had this group of people who they formed a group called Students for Fair Admissions. And what they're basically saying is it's in the name, fair admissions. They do not want affirmative action, which in their minds is a preference, a legal preference. They are saying there's no need for it. People should be awarded and given spaces in higher education based on their merit, based on their work. All right. And so you had, again, two cases, oral arguments on the same day, which was Halloween. You had Students for Fair Admissions versus President and Fellows of Harvard College, Harvard University, really. And then you had Students for Fair Admissions versus the University of North Carolina. Both of these oral arguments were made on the same day. For the Harvard case, the legal issues are, may institutions of higher education use race as a factor in admissions? And if so, does Harvard University race-conscious admissions violate Title VI of the Civil Rights Act of 1964? Okay. Then you have in the University of North Carolina case, Those legal issues were also, may institutions of higher education use race as a factor in admissions? And if so, does UNC's race conscious admissions process violate the 14th Amendment of the United States Constitution? Meaning, does taking race into consideration violate the equal protection section of the 14th Amendment of the United States Constitution? Now, originally, these cases, they were put together, they were consolidated. But at the time, Justice Ketanji Brown Jackson was not a justice. So what ended up happening is, because she sits on the board, I think, of trustees for Harvard, and because she is a Harvard grad, she recused herself. So that takes the justice number from 9 to 8. What it does for composition wise is it takes it from 6 conservative, 3 progressive to 6 conservative, 2 progressive. Okay, keep that in mind. Now, for the University of North Carolina case, she's still on that. She is still able to make a decision because there is no conflict of interest. So they consolidated the cases, and then they had to separate or sever them because of the potential conflict of interest that Justice Jackson had. All right. So these are the 2 cases that the nation is waiting on the Supreme Court to make a ruling on as to whether or not affirmative action is going to completely be eradicated, if it is going to be affirmed in part, or if it's going to stay just as it is. Now, in talking about the composition of the United States Supreme Court, these are the persons that sit on the Supreme Court. The most conservative justices are Justice Roberts, Justice Thomas, Justice Alito, Justice Kavanaugh, Justice Gorsuch, and Justice Coney Barrett. Okay? Even though John Roberts is the Chief Justice of the Supreme Court, Clarence Thomas is the most tenured. He has been on there the longest. I think he's been on there at least 30 years, whereas the person who is the next closest in him in terms of time on the Supreme Court is Roberts. I think it's at 15, 16, 17 years. But those are the conservative justices. And then you have the more progressive justices, which are Justice Kagan, Sotomayor, and now Brown Jackson. Okay, so whenever there is a determination, the majority, it has to be at least 5 justices deciding one way or another. So the breakdown can be, of course, unanimous. And then for the more contentious issues, it could be a 5-4, 6-3, 7-2, 8-1, 9-0. Okay. I believe that this case is going to be 6-3. There's going to be 6 justices that are going to vote one way, and then you're going to have 3 justices that are going to vote another way, and then you're going to have what are called concurring and dissenting opinions. Concurring opinion is where you agree with the majority, but you agree for different reasons, and you want to stand out and say, hey, I got something to say and I want to write my own opinion. So I think there are going to be concurrent opinions. I think there are also going to be dissenting opinions, because what could be a dissent today could be part of a majority opinion tomorrow. And so I think for a situation like this, you will hear some dissenting opinions from the justices, those that don't agree with whatever the Supreme Court is going to rule upon. And then that is going to set the end of the Supreme Court term, and they will not be back again until October. So in terms of predictions, in Greta versus Boilinger. Now, remember I told you the 2 cases in 2003 that were decided on the exact same day. Justice Sandra Day O'Connor, who was the first woman associate judge on the United States Supreme Court, she said in that opinion on October, whatever day it was in 2003, she said that affirmative action in college admissions is justifiable but not going to be in perpetuity, meaning it's justified that affirmative action exists, but it's not going to need it. Is the need for it is not going to go forever and ever and ever. She said, quote, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest in student body diversity approved today." That's what she said in 2003. 25 years from 2003 brings us to 2028. My prediction is that affirmative action is not going to last that long. I believe that in this decision that the Supreme Court is looking at, these two decisions, affirmative action is going to be eradicated by the United States Supreme Court. And I say this because of the way in which oral arguments were made, that the certain questions that justices ask, if they are held by those questions, then they are, in a sense, tipping their hand. You have on the Supreme Court, you have justices that are considered to be very conservative. They are also what are called strict constructionalists, which means that when you read the Constitution, if it is not in the fine print of the Constitution, they consider that to be something that you infer. And so what they always try to stress is look at the intent of the framers and the writers of the Constitution. So in the Dobbs v. Jackson case, you had Justice Clarence Thomas concurring with the majority that says get rid of abortion rights. But in his own concurring opinion, he stated, well, while we're looking at all of these precedents, we need to go back and review some of the earlier decisions that the Supreme Court, not him, but other Supreme Court justices make. And so he already said in plain text, in plain conversation, look out, because the rights that you have today will not be the rights that you have tomorrow. And he went on to name some of the cases that he recommends needs to be overturned and overruled. So it is with that language from the Supreme Court justice who has been on it the longest that is what fuels what I believe is going to be the eradication of affirmative action. I believe that when the Supreme Court issues its opinion, it is going to couch its opinion, of course, in precedent, in what are called amicus briefs, which are briefs, written legal summaries that are written to the court that says, look, although we're not a party, take this into consideration. I think that it's in their mind is going to be time for a change. And so I could almost bet my bottom dollar that this quote that I have just read to you is going to be in somebody's legal opinion, because they're going to use that and say, look, affirmative action was just a start. It was not a solution. It's a means to an end. And now, because we live in a post-racial society, we no longer need affirmative action. Let's get back to times where you just got in because you earned it. Okay. Now, in terms of those situations where you have legacy admissions, where people get in because their mama or their daddy or their great person was a founder, a trustee, an alumnus of that university, that's something different. Not really, but you will have those who will make those arguments. And so I hope I'm wrong. I hope that they retain affirmative action, or at least some iteration of it, but I don't think that's going to happen. Okay, so I have this on here because that is the end of my presentation. Like I said, I wasn't going to hold you long. I just wanted to explain some things, take some questions, address some concerns. If you have a QR reader on your phone, you can just hold your phone up here, make sure that the QR code is within the frame, and then it will take you directly to my website and how to stay in touch with me. And then also, I am on social media. This is my email. These are my websites. you can definitely stay in touch. And if there's a situation where you or your organization or your institution wish to create ways that affirmative action, if it's eradicated, because now we have to address all these DEI initiatives and positions and things like that that came up, especially around 2020. Now there's a possibility that you're not going to be able to rely on affirmative action. So, what plans, what policies, what procedures do you put in place so that you are able to make sure you are in, maybe not in agreement, but definitely in good legal standing? Okay, so those are the ways in which you can communicate with me. I'm going to go over to the comments to make sure I didn't miss anything. Hello, I see my friend, my soar, Monique Crane spells hello. Yes, it's a low threshold for regular determinations. But this particular determination of affirmative action, that is going to be at the highest level. And I believe that the Supreme Court is going to say, you're welcome, that the Supreme Court is going to say that there is no compelling state interest. I believe that the Supreme Court is going to say that diversity is no longer a compelling state interest because of the fact that there is no need for it. And then there is going to be a huge infusion of legal terms, legal words, which is just, it's, I almost want to say they're going to be working backwards. They're going to start with, we're going to overrule affirmative action. Now, what can we say? What can we do to legalize it and to make sure that this is becoming the norm and not the exception? Okay, so those are my thoughts. Now, of course, this presentation is free to you, but it is not free to do, meaning that there are always costs and things associated with it. So I never, ever, 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 ever turn down any way for the community to support. If you want to do it through Zelle, you can do it that way. My name is listed if you want to do it by way of PayPal or Cash App. These are the ways. You can email through legaleazeplease@gmail.com. Cash App is $legaleazeplease. Now, this is not because I am begging. No, it is not that. It is because I see myself not only as an institution, but also as an investment. And so coming online and providing these community offerings, engaging in community conversations, there are costs with that, such as getting the social media rights, the subscriptions, the lighting, the research, all of that is lovingly provided to you. Okay, but it is not lovingly all the time given to me. There are costs, as you know, in life. And so if you are moved by anything that I said, understand you can always give because it's in your heart, give because of your kindness, your generosity. And if you don't, it's okay too. But my goal is really to make sure that the information is not withheld from those who need it most. And so if I were to have a conversation with you, I would definitely recommend that you and your organization start talking about what if affirmative action is eradicated? What do you do to maintain diversity in different ways in your organization, in your schools, on your jobs, in the military? Whatever way is inspiring to you, I would definitely suggest that you have those conversations if you're not already having it. And then, of course, if you need people like myself to come in to help you work through some things, you know where to find me. You know where to find me. You can email me at legaleazeplease@gmail.com. You can go to the website, and that is where my contact information is. I also have a last ask of you is that you would subscribe to the YouTube channel, which is Legaleaze Please. make sure you do your spelling ease with the Z so that we are able to continue to provide quality, free, informational episodes about the law to you. All right. So with that, that is the end of this Legaleaze Please episode. If you have not already, please make sure that you click like and you share this on your platforms. Thank you so much for your presence, for your attention, for those who are here live, for those who are coming later to watch. Please know that we see you. And even though we are not in real time, we are still connected. And thank you for your support. Have a magnificent week. Take care. Bye bye.